Ware Wendell. Again, tell us your name, who you represent, and your position on the bill.
Yes, sir. Thank you, Mr. Chairman, members of the committee. Again, my name is Ware Wendell. I'm the Director of Legislative Affairs for Texas Watch. And respectfully, Chairman Madden, we're opposed to House Bill 2031. We oppose it because we believe in practice it could lead to the concealment of wrongdoing, adding delay to the legal process, and inducing victims to make uninformed decisions about their damages, which would ultimately allow wrongdoers to escape accountability. We're concerned that the practical effect of the bill would not help victims, and instead it would help wrongdoers to compel victims to settle quietly and cheaply. As was mentioned earlier, civil lawsuits are about apportioning fault, but they're also about discovering the truth. And we do that through the adversarial process, and that's important for public policy reasons. We do that so that we can learn from those mistakes and so that those mistakes are not repeated. Under this bill, I'm concerned in Section 160-151, setting up a plan is not an admission of liability, but then it goes on to say in 152 that it's not admissible either in a civil context or a criminal context. So where you've got criminal charges that have been filed, this sort of activity on the criminal defendant's part is not admissible. And then finally, that it's not subject to disclosure. And discovery and disclosure is an important function. We saw that in Texas City. And hearing about the three little pigs, there was an internal document that came to light in the course of that litigation that showed that BP was making light, basically, of how much money they would spend to try to harden that shed. And they decided not to spend as much money, and a lot of people lost their lives as a result. Participants who are interested in misusing this fund can basically dangle this money out there, and it can be hush money, and it will abrogate the discovery process. If you look at the policy here, and I don't think that this is the intention, but what we're doing is rewarding the worst conduct with special privileges. If you kill people, you can abate a lawsuit, and that's deeply concerning to us. It also invades the attorney-client relationship in inducing those victims to talk to the one who killed their family directly. That's not sound public policy. The defendant doesn't have to answer for their wrongdoing. They can abate the suit for at least 3 months. And Judge Lewis, I believe you would know this better than anybody given the breadth of your legal experience. Attorneys have two roles. We're both advocates, but we're also counselors. That's why it says that we're attorneys and counselors at law. And so much of what we do is talking with the client about what their rights are, what a jury may do here, what information can come to light, what the possible apportionment of fault is across the different defendants. And basically, this fund will set it up to where the victim is flying blind here. I'm thinking of an 18-year-old who just lost both of her parents to an 18-wheeler. The driver's been driving for many hours and is high on amphetamines to stay awake and kills her mom and dad. Under this bill, she, the grieving daughter, has to go talk to the wrongdoer and try to make an educated decision. She should have informed consent here. She should have the benefit of an attorney. I won't repeat what's already been said about how the plan administrator is not necessarily impartial here. Under this bill, human misery can be reduced to something that wrongdoers can budget around. It's neat and tidy. It can be a line item on an SEC filing. It's a transaction of business expense. And that's deeply concerning. It's a recipe for repeat disasters. Your constituents may be endangered by it, and we would respectfully urge this committee to oppose this bill as written.